Madam Deputy Registrar, can you please commence the proceedings?
Thank you, President. Caribbean Court of Justice, appellate jurisdiction on appeal from the Court of Appeal of Barbados, judgment delivery in BBCV number 2 of 2022 between Apsara Restaurants Barbados Limited and Guardian General Insurance. The members of the delivery panel are Mr. Justice Saunders, President and the presiding judge.
Good afternoon, Counsel.
Mr. Justice Anderson.
I think Mr. Justice Anderson is not going to be with us, nor will Justice Jamadar.
Thank you, President. Madam Justice Rajnath.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon, all.
And Mr. Justice Burgess.
Good afternoon, Counsel.
May we have the appearances, please? Thank you.
Please, Your Honors, I appear on behalf of the appellant in this matter. My name is Douglas Mendez. I'm leading Clay Hackett, who is also instructing me, and he's here with me in the room.
Good afternoon, Justices. I appear on behalf of the Respondent, Guardian General Insurance Limited. I'm Christopher O'Dane. I appear with Mr. Roger Ford, KC, who regrettably is unable to be here this afternoon.
Yes, well, good afternoon again to you and to everyone who is listening. I propose to read a summary of the court's decision. There were 3 opinions and they were fairly lengthy. And so the summary naturally is going to be also a little lengthy. I wish to have you excuse the absence of Mr. Justice Anderson and Mr. Justice Jamadar, but they have signed the judgment, which will be made available after these proceedings. This summary, of course, is not intended to be a substitute for the reasons of the court or to be used in any later consideration of the court's reasons. This appeal was brought by Apsara Restaurants Barbados Limited, Apsara. Apsara is a company with 2 directors, Mr. Mohammed and his wife, Ms. Kavanagh. The respondent is Guardian General Insurance Limited, Guardian, a company doing insurance business in Barbados. The case was heard by all 7 judges of the court, but regrettably, before today, before the judgment could be delivered, Justice Witt retired from the court on the ground of ill health, and he passed away shortly thereafter. His inability to participate in the deliberations did not affect the outcome of the appeal, as all remaining 6 judges have agreed that the appeal must be dismissed, albeit there were varying reasons. In the early morning of 27th August 2007, fire destroyed Apsara's restaurant premises situated at Morecambe House at Maxwell, Christchurch in Barbados. Apsara lodged a claim on a fire insurance policy it had entered into with Guardian in relation to the burnt premises. Guardian resisted the claim on several grounds. The main ones surrounded the allegations that A, Mr. Mohammed was responsible for the fire, B, in proposing for the insurance coverage, Apsara did not disclose several material facts and thereby induced Guardian to effect the coverage on the premises. And C, Apsara was in breach of one of the conditions of the policy, condition 11. The trial judge found overwhelmingly for Guardian on each of these points. The judge was not impressed with the evidence given by Apsara, and in particular by Mr. Mohammed. The Court of Appeal dismissed Apsara's appeal. That court found no reason to disturb any of the findings of fact or law made by the trial judge. Apsara appealed further to this court. Given that the Court of Appeal endorsed the trial judge's factual findings and inferences, the questions facing the CCJ for decision could really be boiled down to the following. A, what is the legal consequence of the concurrent findings of the trial judge and the Court of Appeal? B, should this court reverse or uphold the judge's finding that Mr. Mohammed was somehow involved in the deliberate fire that took place at Apsara's premises? C, Was Guardian entitled to avoid the policy on any of the various grounds of non-disclosure claimed by Guardian? And overarchingly, what is the right test for assessing the materiality of non-disclosed facts? In particular, in relation to the issue of non-disclosure, Apsara had not, at the time it or its broker signed the Guardian proposal form, disclosed to Guardian the fact that an insurance company in Trinidad and Tobago, Gulf Insurance Company, had previously cancelled a policy of insurance effected some years before in Trinidad and Tobago by Omera Food Products Limited, a company of which Mr. Mohammed and Ms. Kavanagh were the sole shareholders and directors. The question, therefore, is whether that non-disclosure entitled Guardian to avoid the fire insurance policy on the premises in Barbados. Secondly, Apsara had not, at the time it signed the Guardian proposal form, disclosed to Guardian the fact that an insurance company in Trinidad and Tobago, Maritime General Insurance Company Limited, had previously denied an insurance claim made by Omera. Did that non-disclosure entitle Guardian to avoid the policy on the premises in Barbados? And thirdly, Apsara had not disclosed at the time it signed the Guardian proposal form that there was an unpaid judgment debt in Trinidad and Tobago for the sum of the equivalent of approximately 300,000 Barbados dollars registered against Omera. The question was whether that non-disclosure entitled Guardian to avoid the policy. Further, did Apsara fail to comply with condition 11 of the policy? And if it did so, did that breach entitle Guardian to avoid the policy on the premises in Barbados? By a majority, Saunders, P. Anderson, Barrow, and Jamada, justices, the court held that it was entitled to review the concurrent findings of fact of the trial judge and the Court of Appeal. The majority held that if any particular fact and issue was an inference reached by the trial judge, the court should not decline to review that inference merely because the Court of Appeal supported the trial judge's finding. Secondly, if the fact and issue is the primary fact found by the trial judge, then if the Court of Appeal endorsed that finding, the court may still review it in certain circumstances, including where there was no or no sufficient evidence to support the finding of the trial judge. The minority, on the other hand, Justices Burgess and Rajnath Lee, took the view that the court should decline to review the concurrent findings of fact in this case, taking into account that Apsara had not disclosed any exceptional circumstances as required by this court's jurisprudence. On the issue of arson, by a majority, Saunders P., Justices Anderson, Barrow, and Jamada, the court held that there was not sufficient evidence to justify the trial judge's conclusion that Mr. Mohammed was responsible for setting the fire. The majority's view was that neither the trial judge nor the Court of Appeal appeared to have taken into account circumstances that pointed away from the notion that Mr. Mohammed was the likely arsonist. On the question of non-disclosure material facts, and in particular, whether Apsara had failed to disclose material facts, thereby causing Guardian justifiably to avoid the policy, counsel on both sides of the appeal, like the courts below, had uncritically accepted the test for materiality as laid down by the House of Lords majority in the case of Pan Atlantic Insurance Company Limited versus Pine Top Insurance Company Limited. The House of Lords held in that case, the Pan Atlantic case, by a 3-2 majority, that a fact or circumstance is material if a prudent insurer would have wanted to know about that fact or circumstance when forming an underwriting judgment on the risk, if it had been offered to them, even if the prudent insurer might have made the same underwriting decision as the particular insurer in question had done. The House of Lords in Pan Atlantic also unanimously agreed that, further, a court will only allow avoidance of the policy where the actual insurer establishes by evidence that they had been induced by the non-disclosure on the part of the assured to accept the risk undertaken, or to accept the risk on the terms that ultimately they did. This view of the law taken by the House of Lords majority in Pan-Atlantic may fairly be said to be the prevailing law in Barbados at this time regarding the test for materiality. The CCJ judges were evenly divided on that test. Justices Burgess, Rajnotley, and Jamadar took the view that the test for determining materiality was as laid down by the House of Lords majority in Pan-Atlantic. On the other hand, Saunders P., Anderson J., and Barrow J. agreed with the position adopted by the House of Lords minority in Pan-Atlantic. A fact that is not disclosed is material only if a prudent insurer, if he had known of the undisclosed fact, would either have declined the risk altogether or charged an increased premium. Further, to avoid a policy, the actual insurer must provide cogent evidence to establish if they had been made aware at the outset of the circumstance that was not disclosed. Further, to avoid a policy, the actual insurer must provide cogent evidence to establish that if they had been made aware at the outset of the circumstance that was not disclosed, they would have declined the risk or charged an increased premium. The court was therefore evenly divided on this issue. The practical effect of this equal division of the court as to the proper test for determining whether a non-disclosed fact is or is not material means that in Barbados, the law on this point remains as it was before this judgment was issued. As to the admitted non-disclosures, by a majority, Saunders P., Anderson J., Barrow J., and Jamadar J., the court held that given all the surrounding circumstances, Apsara's failure to disclose to Guardian that Gulf Insurance had previously cancelled a policy of insurance effected some years before in Trinidad and Tobago by Omera was not by itself a non-disclosure that entitled Guardian to avoid its policy with Apsara. By a majority, or by the overwhelming majority, given that Justice Witt did not take part in the proceedings, by unanimity, the court held that Apsara's failure to disclose to Guardian that Omera had previously made an unsuccessful claim on an insurance policy was a material non-disclosure, which entitled Guardian to avoid its policy of insurance with Apsara. The court also considered Apsara's failure to disclose to Guardian that in Trinidad and Tobago, a judgment had been recorded against Omera, Mr. Mohammed, and Ms. Cabana, jointly and severally, by the Agricultural Development Bank of Trinidad and Tobago for the sum of TT dollars $1,060,075.19, or approximately 300,000 Barbados dollars, and that this judgment was outstanding at the time Apsara made its proposal to Guardian. All 6 judges considered that this also was a material non-disclosure which entitled Guardian to avoid the policy of insurance. On the question of Condition 11, the courts below had both held that the failure by Apsara to provide Guardian with particulars of the loss incurred due to the fire within the 15-day period stipulated in Condition 11 of the policy was such that Guardian was not obliged to honor Apsara's claim. All 6 judges held that given the extenuating circumstances revealed by the evidence, Apsara's failure to provide the particulars within the stipulated time did not entitle Guardian to avoid the policy on this ground because Guardian's conduct amounted to a waiver of the requirement for strict compliance with Clause 11. On the issue of costs, in light of the requests by counsel for the appellant, we will hear counsel on that issue before giving our ultimate decision. And I don't know whether Mr. Mendez, it was your intention to address us on this issue now, or whether you had in mind some other mode of communicating your views on costs.
Well, to be honest, until I appreciated that Justices Anderson and Jamadar would not be attending today, it was my intention to address you orally, but given their absence, it's probably best that I take the opportunity to pen a short submission on that question. And maybe if you could give directions that we do so within the next 7 days.
Certainly.
President, if I may inquire, just as
Yes.
a matter of avid curiosity, what is the substance of your contention, Mr. Mendes?
I can say it very simply, Justice Barrow. If costs are to be assessed, and it is usually assessed on the basis of the amount of time spent by counsel on a matter, then we would respectfully submit that Mr. Ford and his team would have spent far more time dealing with, and also the court would have spent a lot more time dealing with the points on which the appellant has been successful. So I would say, just to use a figure, that the time spent on those matters may be in the vicinity of about 75% of the time. So that if the award of 60% stands, it means that the appellant would be paying for part of the time that Mr. Ford and his team spent on the issues that we won on, so that they would be getting reimbursed for time spent on issues that they in fact lost. So that is in essence the submission which I wish to make.
Very clear, Mr. Mendes. Thank you.
Yes. We take a short adjournment, and the bench will meet among ourselves, and we'll come back with the timetabling and the modalities for addressing this issue.
President, before we do that, is it that counsel for the respondent wishes to say anything?
Well, thank you very much, Your Honors. I certainly would be keen to see the submissions of Mr. Mendes so that we have an opportunity to respond. Our view was that the court had been exceedingly generous in the discount of costs that it had awarded, and therefore we would not be expecting a further discount, but certainly we would want to see what Mr. Mendes is submitting to the court. So we would certainly want an opportunity to respond.
Okay, so give us 5 minutes, and then we'll be back with you.
Certainly.
Okay, so Mr. Mendez, we will give you 7 days. That's until the 29th to make your submissions on the issue of costs. And Mr. Odein will give the respondent the same 7 days. So 7 days after you receive Mr. Mendez's submissions, or 7 days after the 29th, if he gives us on the 29th, which would be on the 5th, we would expect to receive your submissions, and then the court would issue in writing an order that resolves this particular issue.
Thank you very much, Mr. President.
Okay.
Much
So
obliged to
that-
the court.
That concludes our judgment delivery in this matter, and we thank counsel for their previous submissions and for your attentiveness. Thank you very much. Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Madam Justice Rochner-Cleves. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. Thank you, counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you
Good
all.
day.
Thank you very much.
Good day.